as you know, the First Amendment includes the right to make mistakes, lots of them. And I'd like to first thank Jane for the gracious welcome. It was about a decade ago, I was honored to serve as on the executive committee of the U.S. Capitol Historical Society, and have been so honored to be part of their constitutional education for over a decade. And I really support the efforts they've made toward broader constitutional education. And I'm very honored to be here as part of their series on the First Amendment. Having watched the presentations on freedom of speech, freedom of religion and freedom of the press, I'm very honored to be here. So my task today is to talk about the rights, one of the rights Americans tend to list as the most high is speech. We know that because we just had an excellent survey by the Freedom Forum. I suggest you check that out. That says that speech is the right that most Americans rank highest. I'd probably rank religion, but they're connected. This idea of freedom of conscience, that the government's not supposed to tell us what to think, what to believe. And then assembly and petition, they're last. And in modern parlance, we don't really think about the right to petition as much, but you'll see in my presentation why there are times in American history when the right to petition was the most important. So let's go. I was asked to talk a little bit about what our framers and ideas were about the First Amendment. And I love history, so here we go. First of all, the First Amendment, as you know, includes at least 5 different rights. Religion has 2 packed into it, the non-establishment clause and also free exercise. And today, I've put them in order, which I think is important. I'm always studying the original text and primary sources. But today we're going to look more at speech and then assembly and petition. Well, first of all, when we talk about the framers, and the Bill of Rights, what is there to say? The first thing is the framers, at least when I went to law school, those are the people who actually were involved in writing the Constitution. Well, when they signed that document on September 17, 1787, there was no Bill of Rights. I think you tell most Americans today, whoops, the framers forgot the Bill of Rights, they'd be shocked. And when the Constitution went up for approval to the states, many states said that they really wanted the Bill of Rights to be promised once the new government got going under the first Congress. And some states like North Carolina refused to ratify the Constitution until a Bill of Rights was actually submitted by Congress to the states, and then North Carolina ratified both of them at the same time. Well, you know, James Madison is probably my favorite founder, and because he was both a philosopher and a practical politician. Remember, he serves in the first Congress under the Constitution. So he's able to take these incredible lofty ideas, but then put them into practical politics. And any of you who have served in Congress or been in Congress, you know what a difficult job that is. Madison, of course, was the architect of the original Constitution. He was what I would call the editor of the Bill of Rights. When he got to Congress, and he had defeated James Monroe in Virginia to get that job, and as part of it, he had promised the voters of Virginia that yes, even though he had initially opposed the Bill of Rights, he would become its chief sponsor in the first Congress. Why did Madison change his mind? You know, some people accuse him of being a flip-flopper. I think that's not true. I think what he said was, and you can read, there's a letter he wrote in 1789 in August that tells a friend why he changed his mind. And he said, first of all, he was never really against the Bill of Rights in general, and that it could help. He just didn't think it was necessary, and he was afraid it was being presented as an obstacle to the Constitution, perhaps not in the best of faith. But he felt like it was important to give it to the people. Remember, the ratification conventions, at least at that time, were popularly chosen. They weren't chosen by the state legislatures. He thought it would give the people quiet, as did President Washington. And then what he says at the end is, the main reason I'm doing this is because I'm an honest man, an honest man. And I promise my voters, my constituents, this is what I'm going to do. And this is what he did. As you can imagine, though, with any process of legislation, and let's remember, the Bill of Rights is a piece of legislation. It went through lots of amendments. We'll see now the different proposals Madison made, the multiplicity of them. And at one point at the end of August, and remember, they're in New York, but it's still a hot summer at that point. And by the end of that session, Madison says to a friend, the friend makes a little joke about a nauseous project. And Madison replies, well, yeah, but he's still for it. But, it's hard to think of, well, at some point our founders thought the First Amendment was a nauseous project. But let's see what happened. Well, here's the actual Bill of Rights. At the top of the document is Congress of the United States, again, reminding us that the Bill of Rights comes through a collaborative process with lots of changes along the way. Madison introduces the first draft his first proposed amendments in June of 1789, 28 amendments that were going to be scattered throughout. Well, one of his antagonists said, no, we should put them at the end. And I think today we appreciate the fact that they're at the end and not scattered throughout the original document. To us, that gives them more importance. Eventually, there's 12 proposed amendments that the Senate signs off on as well. They're sent to the states September 25th. Finally, 10 ratify, the necessary 10 by December of 1791. And your Jeopardy question is, 2 of those weren't approved then, but they were added later. One was added in 1992. You're perhaps familiar with that story about a college student taking it on as a project, and then later on it becomes added. It's the one that says Congress can't get a pay raise until the people get a chance to either vote for them against them or for them again or not. So ultimately the people get a choice about pay raises. Now here's a little document that is probably, when I did all my research about the First Amendment, was my favorite discovery. It's in the Library of Congress. You may know that at the time, the Senate didn't have a formal journal. The House's journal, they had newspaper people that would sell the proceedings by subscription. And so private people would come in and take their notes and then sell that. Well, here are the notes of Thomas Lloyd. And he was the person who was in charge of taking notes during the first Congress, including while the Bill of Rights was ratified. And you can see, not ratified, proposed. And you can see, I love the drawing of the horse, the person in the hat. This is the next march. We see his numbers. But if you were studying for a test, are these the notes you necessarily want to see? And usually not. So when we're talking at least about the framers in terms of the people in Congress, and that's different than the framers of the Constitution who were coming up with this language, those are the notes we have to use. So let's look at some of the basic principles of free speech now that we're narrowing in here. And I think this example here, written by Justice Robert Jackson in 1943, when we were in the middle of World War II. As you may recall, Justice Jackson goes on to lead the Nuremberg prosecutions. And it's a tremendous person in our Supreme Court and judicial history. Well, here is an example. It comes from a case. For those of you who might not already know, this comes from a case about mandatory salutes to the Pledge of Allegiance, or salutes to the flag, including a Pledge of Allegiance. And you may already know the photo to the left actually is taken from a school in Connecticut. Many people think when they see this picture, okay, it's a school in Nazi Germany, because that's the salute we associate with Nazi Germany. Well, that was what was common until after World War II. And Jehovah's Witnesses, both in Nazi Germany and America, refused to give that salute. They thought it was a form of idolatry, and they were not going to salute whether it was the Führer in Germany or the U.S. flag in America. They were not going to they were not going to go along with that practice. And the Jehovah's Witnesses are really discriminated against before it. There's violence. The first decision comes down and it's against the Jehovah's Witnesses. Yes, you have to have patriotism, and children must participate. And then only 4 years, it's the quickest reversal thus far in Supreme Court history. And Justice Jackson gives this assessment. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. That's the bedrock principle, is that government officials cannot force Americans using their power of government to ascribe to any particular oath or opinion or religion, or even patriotism. Justice Jackson will say that to force people to practice patriotism really underestimates the appeal of free institutions to free minds. Well, let's go on to a modern controversy, kind of testing this principle as expressed by Justice Jackson. This is a young man I've been honored to get to know personally. His name is Simon Tam. He was involved in a Supreme Court case about his band, which he's Asian American, and he wanted to name his band, along with his bandmates, the Slants. As you know, groups can sometimes choose to adopt a derogatory name as a way of disempowering it and really turning the tables on the oppressor. It's like, you think you're calling me something bad? I'm going to embrace that as a badge of honor. And that's the way Simon Tam saw it. So when he applied for a trademark for his band to the U.S. government, and he was told multiple times, well, this term is derogatory to Asian Americans, so we can't allow you to use that. And as you know, the Trademark Office had been applying that principle to other things like the Washington football team. And there were people in support of that, people who were opposed to that. And what Tam says is, wait a minute, he looked at the word slants and it was in all kinds of trademarks. So other people were being allowed to use the term, but he said, his quote is, "I may be the only person denied a trademark for slant because it was deemed offensive to Asian Americans." And when we talk about that notion of hate speech or free speech, as we know, in other contexts, the Supreme Court has ruled that there cannot be laws, the government can't pass laws outlawing hate speech. Now, it can be used as an aggravating factor if there's illegal action hurting someone, But to just punish speech by itself without illegal action, the Supreme Court has said that's not allowed. So when Simon Tam takes this case to the Supreme Court, it takes 10 years. It takes 10 years. And essentially what the Supreme Court rules is what Simon believed is, wait a minute, I don't want the government choosing between good speech and bad speech. That's not the government's role. And the Supreme Court agreed with him unanimously. So it took him 10 years, and I encourage you to read his memoir of how expensive it was for him in lots of ways, not the least of which people in his own community disagreed with him. But it asserted that principle. There are things we don't want the government to do. So let's talk about that related to social media. We are hearing today a lot about, well, should the government require social media to follow First Amendment principles, even though all of the companies involved are private companies? And we have that principle generally in the US that private property follows private rules. You know, I don't get to tell the Washington Post what to publish. Social media have become in a lot of ways like the press today, and that they have a right to editorial judgment and editorial concerns. The other question that's come up is, should the social media be regarded as like a public utility? Justice Clarence Thomas has even suggested that. But again, when the government has a public utility function and can regulate a company because of that, remember, it's still government licensing the provision of that. So if we were to suddenly say that speech in certain cases is like a public utility, then we're giving the government license, a permission to license again. And that's always been a stance we would not approve. Well, so let's talk about other types of speech. We're talking about now looking at speech versus action. Remember, there's no absolute right in the Bill of Rights, and that includes the First Amendment. So whenever what we would call like pure speech becomes more like speech with action, what we think of today as demonstrations, or is a way that we think of people taking, showing their free speech rights. This came up back in World War I when women were fighting for the right to vote. They were picketing the White House. That had never really been done before. And they were trying to publicize, and this was during a time where war was impending. It was breaking out in Europe and it was impending in the US. And what the women are saying here is, wait a minute, how can we say that we're in favor of democracy when German women have the right to vote and we don't? So they're challenging President Wilson on this. And they were arrested and put in jail. Those of you who are not familiar with it, the workhouse in Lorton has a wonderful exhibit about the suffragists who were jailed there. And you see Lucy Burns on the left, and then this young woman, Rose Winslow, on the right. She was immigrated to the US from Poland, and she was a very fierce advocate of women's suffrage, and she suffered for it. She was jailed, and she tells the descriptions of how she and Alice Paul are force-fed. They go on a hunger strike because they're saying, wait a minute, we're political prisoners during this time, and we want to be treated that way, and we can go on a hunger strike so the world will pay attention. And they force-fed the women there in a very gruesome process. I encourage you to read her book about that. And here's what she said. All the officers here know we are making the hunger strike that women fighting for liberty may be considered political prisoners. And we've told them, God knows we don't want other women ever to have to do this over again. So what I want to say today is, yes, we're indebted to the people in Congress who got us the final draft of the First Amendment, but it was a right that we, the people, asked for. You know, we demanded it in the ratification process. And now when we're looking at those rights, we want to look at people like Rose Winslow and Simon Tam, who have fought for those rights for us all to stand on. So when we look at freedom of assembly and petition, I've kind of presaged it here for you with the speech in action, with the petitions, with the suffragists. But before the 1900s, petition was really the way to protest. I mean, the Cherokees, when they were before they were actually forced to be removed, there's one protest that's at the National Museum of the American Indian, has 11,000 signatures on it. And Congress does not recognize their petition, but it shows how the people who were told from the very beginning that they didn't count in We the People, that they weren't included, refused to believe it. That's why I'm still a constitutional scholar today. I recover those stories of people who refused to believe it. And the Cherokee in their petition say to Congress, wait a minute, we have these treaties, we have a Supreme Court decision that supports our rights, and they exercise their rights. The thing about freedom of assembly and petition is that it's not even applied to the states until the 1930s. You may be familiar with the process called incorporation, where eventually the Supreme Court will apply the Bill of Rights to the states. Before the 14th Amendment, it applied purely to the national government. And many local places just forbade demonstrations at all. And finally, there's a case where the Supreme Court says, wait a minute, streets and parks from time immemorial are supposed to be what becomes known as a public forum. The thing is, though, the states and the localities can place place and manner restrictions on these demonstrations, but they have to be content neutral, meaning you can't say, well, we have one rule for this political group and another rule for another political group. It has to be consistent. And then the bedrock principle for freedom of speech that can be prohibited is speech, and punished is speech that advocates imminent lawless action. It can't just be a unlawful idea in general. It has to be imminent lawless action. So let's see how that's been applied. Well, for those of us who were watching live, as many teachers and educators were on January 6, 2021, this is right before it's getting darker toward the end of the day. And you see well, I don't have to tell you, those of you who are watching already know what happened that day. And I salute the society for doing an oral history for people of all political parties who actually were part on Capitol Hill that day and saw what happened, to submit your oral history to the society. It's a very profound time in our country, one that I never thought I would see. And it reminds me of why I went into public education to start with. This was the quote I found. I know this isn't the most current quote, but I've got lots of affection for Justice Ginsburg because she agreed to write the foreword to my book. And this quote I found in the Harvard Law Library. It really set the direction for my path in life. It's a quote by Judge Learned Hand during World War II at an event called I'm an American Day. And Judge Hand knew that Nazi Germany had a constitution. Various other places have had a constitution. And here's what he said: liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. And I firmly believe that. I believe that 30 years ago. I believe it more than ever today, that our constitutional system ultimately depends not on institutions, although institutions are good, but on the people upholding those values in their day-to-day life. So I'll stop there for questions. Questions are my favorite part, and I appreciate you being patient till now. Thank you.
Well, thank you so much, Linda. This is, certainly given us a great perspective on the history and what's going on now. Let me just give you a few questions that people were, as you were talking, one of our listeners was asking about the antebellum period. And during that time, Congress decided they weren't going to hear about anyone who wanted to advocate for abolition.
Absolutely.
And so he wanted to know, like, how did that work? Why could they do that?
Because, and some people have in fact said that the court, or there should have been a requirement that they act on it, that was the missing link. But as you know, working with Congress members, essentially every letter is a petition. And if we required I don't think it was right, but if we required Congress to act on every letter, is that something that would in fact be a judicial mandate on a separation of powers issue? But they did. They absolutely did. They stopped hearing the petitions of the Cherokee as well. And I'm glad our participant brought that up. It was huge. Congress was inundated by petitions. And at that time, the court didn't really get as much involved on any of the First Amendment kinds of issues. And certainly I would say with Congress, that was true too. But to just say you won't receive them at all seems like a gross violation. At the same time, it's also the time when they're about to issue the Dred Scott decision, where it says African Americans, free or enslaved, can never be considered citizens. And the President of the United States, James Buchanan, was actively lobbying the court to jump in and, quote unquote, resolve the slavery matter. So those were times that none of us can consider possible, and yet they did happen. They did happen, and it was a gross violation that Congress made that rule, but they did.
And we got another question from one of our listeners who says that she's a little frustrated that we keep having to amend the Constitution to add people into it. And she's saying, what would we have to do to just revise it to say everybody's included? What are your thoughts about that perspective?
Well, I will say that in general, I think we're overdue for a lot of amendments. So if anytime you want to revise the Constitution, you have to pass an amendment. That's the constitutional system we live under. And if I'm in favor of an ERA amendment, there are other amendments yet to be considered. So in general, we're overdue for amendments, in addition to the one that the reader proposes, which it's kind of like, you kind of want to say, well, let's do the amendment. Equal protection means everybody. Whereas, Justice Scalia, before he died, said, well, the 14th Amendment doesn't really apply to women. So, for certain people who are originalists, they go back to, it was designed to apply to formerly enslaved African Americans, and that's it. So if we do the amendment that the listener proposes, okay, we can do that. And I would also add that we should have a constitutional right to vote for our president, which the Supreme Court has also ruled we don't have. That the state legislatures are the ones who appoint electors or choose the system for electors, and that it can be removed. So I think we need a national voting rights amendment that would also include a fundamental right to vote for the American people for president.
Now, someone asked, this is certainly we're going down looking at what's going on now. And there's been traditionally sort of a separation between religion and government. And do you think that the recent Supreme Court decision that government money can go to religious schools in the Maine case, does that change that separation that we've known?
I think it absolutely does. And yes, we are. I'm happy to take any questions, Jane, that you consider germane. And I think it absolutely does. And I remember, again, coming from this historically, that religious people were the ones that fought hardest for the separation of church and state. I mean, it was Roger Williams in Rhode Island who had been banished by the Puritans. And the Baptists in early America were some of the strongest upholders of separation of church and state, including in Virginia, where they were going to be allowed to take public monies because monies were being given to all churches at that time. And this was before the First Amendment. And they turned it down, saying, wait a minute, if we allow government to help us, we also give that same government the power to hurt us. That was consistent doctrine in American history and in the Supreme Court until just recently. And so now you have state provisions that say, wait a minute, we're not going to give money to churches because we think it's bad for churches. And churches have said that before. And that consensus seems to, at least in the Supreme Court, have very much disappeared.
And let me just say, we've gotten a couple questions about, will a recording be available? Will they be able to see this PowerPoint? Let me assure everyone that everyone registered will get a link to the video soon after this seminar, and you can use it and play it for any of your friends. Somebody's got a book club that's reading your book next month.
All right.
I thought you'd enjoy that. Now let's talk about guns. You know, today.
Okay. Well, now I wasn't really, but I know the decision just came out. Unfortunately, I've written a book about the whole Bill of Rights and not just the First Amendment. So there we go. Go ahead.
Right. So we're gonna just get you down a second.
All right.
To the Second Amendment, because we have you here, and because today about an hour ago, the Supreme Court ruled that overrode the New York law limiting gun access for self-defense. And I must admit, I have not read the document or the analysis, but the question is really not about that case, but about going back to the idea of the originalists. What do you think James Madison intended in terms of, guns? And imagine you're James Madison, and now you're looking at today where we have assault weapons, we have handguns, and how does that relate to the time when he was making the decision about the Second Amendment?
Well, and ultimately he didn't make the decision about the Second Amendment because what he wanted in the Second Amendment was a right to conscience to object to military service. So it is definitely in the context of the opposition to a standing army, and that Congress has this power to create a standing army, and we the people are concerned about that. And as in England, the right to bear arms or to have arms had been taken away from Protestants under Catholic rule. So there's that context. But I will say very clearly that the court's decision in Heller, which says that there's an individual right to bear arms, and some of my, not my colleagues, constitutional scholars have very much come to the conclusion, and it was a liberal scholar who started this, talk about the embarrassing Second Amendment, where he says the right of the people, that's First Amendment, that's Fourth Amendment, that's Ninth Amendment, people is people throughout. Now, we have the right of the militia to keep and bear, or excuse me, the right of the people to keep and bear arms. So well-regulated militia shall not be infringed. Okay, that is a descriptor, but in those days there wasn't a National Guard, et cetera, et cetera. So if we're looking at it in terms of how should a court apply it now, I believe, as many scholars, that yes, it's an individual right, but the point to make is no right is without limits. Freedom of speech has limits. Freedom of religion has limits. And the court in Heller very clearly said that, yes, this is an individual right, but there's all kinds of regulations, no schools, no people with mental illness, et cetera, et cetera, et cetera. So let's go back to the decision today, which said in New York, and I am a little familiar with this, it said that if you wanted to have concealed carry, that you had to show a reason. Well, somebody was out to get you, somebody threatened violence, et cetera. Other states say, and that includes North Carolina, where my husband has the right to concealed carry, is that it's not so much you have to show a reason, but you have to have training. You have to go through. I'm much more willing for someone to be concealed carry than open carry, because you have to have training to have that ability. So where it comes down for me in terms, and as a constitutional scholar, that the Second Amendment does protect an individual right, but the other part of it is getting completely ignored, which is there are all kinds of limits that they're allowed on dangerous speech, much less dangerous weapons. So of course, the AR-15s and things, they were banned before, they can be banned again. It's the political will, again, my point. We can have a constitution, but what does it mean if we, the people, don't support those values? Now, did I answer that question?
You certainly did. And, you know, we've got somebody who really was listening to you when you were talking about the originalists and the original intent, and talking about the 14th Amendment really being only meant to deal with formerly enslaved individuals.
That's what Justice Scalia said, but he's very influential on the court.
And the question that this person put forward is, would that mean that that amendment would not cover African Americans today who are born in the United States, or would only cover people who could distinctly show they're enslaved? You know,
that's an excellent point. That's an excellent point. And, you know, Justice Scalia is often good on First Amendment issues. I mean, he struck down the flag burning laws. Not that I agree with him in all cases for certain, but he's ignoring, you know, when he gets into the history like that, and he says, well, I don't really care what framers' intent is, but you look at the debates about the 14th Amendment, and there are plenty of members of Congress and the Senate who are saying, yes, we intend this to apply to, they mentioned the Chinese who are being very discriminated against in California. We intend it to apply to everybody. Now, they don't include women because that wasn't even on their mindset then. But this idea that you have to do new constitutional, like the listener proposed earlier, are we going to have to do a new version of 14th Amendment that says, you know, equal protection means everybody?
Well, now,
did I answer that question? It's
like,
like,
and it brings up something somebody else asked, is explain the flag burning. You know, how did the flag burning ruling come down, and how was that related to the First Amendment?
Oh, that's an excellent, and you know, for my intro here, I had to just hit some high notes. I couldn't do everything, and I know I've got a great teacher cohort out there, and I'm sorry I left out schools. But looking at the flag burning, you know, that's one of those epic cases where, as you probably recall, there were proposed amendments to the Constitution to ban flag burning. And that would have been the first time that the First Amendment had ever been amended to restrict speech. And we had the principle, and Justice Scalia outlines it very clearly. He says, wait a minute, it's not an individual. Like, for instance, if somebody tried to burn the flag at Arlington or a flag at Fort McNair, that's private property. That would clearly be, you're not burning a symbol, you're burning somebody's specific property. But for the government to ban the idea of burning a symbol, even if you go out and buy your own flag, and remember the idea was that if you look at the flag code, that's still part of the law, you're not supposed to fly the flag at night without proper lighting. You're not supposed to fly it during the rain. If you take on the responsibility of displaying a flag, you're supposed to carry it all the way through. You're not supposed to have the flag on articles of clothing. You're not supposed to, people now like to autograph flags and write on them for various occasions. It's like, no, you're not supposed to do that. That all violates the code. So why are you picking on someone who chooses to burn it as a political expression versus, remember, the proper way to dispose of the flag is burning it. So Justice Scalia was very clear, and the others joined him, of the First Amendment protects speech, and the government can't decide what speech. So, but it came very close. The constitutional amendment came very close, and so that's an example of be careful what you ask for when you ask for a constitutional amendment.
And we've just got a couple more because we're going to run
I'm here
out
for
of
as long as
time.
you need me, particularly since we had the little delay.
Here's what we've done with people before, with our audiences. When it gets to be just a couple minutes before 1, we're going to thank everybody and sign off, give you the update on what's coming events. But Linda has agreed to stay and try to work through some additional questions for another 10 minutes or so. So if you still have questions, keep putting them in. We're going to try to do 2 more, and then we'll break for the announcements of upcoming events. And then we'll come back for those of you who have the opportunity to spend a couple more minutes. You talked about how we might change the Constitution. And we know the amendment process, passing it through Congress, getting the 3/5 of the states, which is a very complex and cumbersome process. There are some folks who have suggested that we call a convention of the states to pass constitutional amendments en masse, which has a lot of proponents and detractors to that idea. Some who would believe that if you were to call such a thing, it would in effect be a constitutional amendment, and the Constitution as we know it would no longer be the governing document of this nation. What is your opinion on such a conversation?
Well, as you know, Article 5 of the Constitution allows such conventions to be called to propose amendments. They're not supposed to, they're still proposed now. The states would still have to ratify, but it would leave Congress out of being able to pick or choose. And let's recall that our current Constitution came from a specially called convention that was supposed to amend the Articles of Confederation, not replace them. However, under that scenario, the proposed new Constitution went back to Congress first. Congress had the choice about submitting it to the states for ratification. And so there was an inherent check in that. So if we call an Article 5 convention, by the way, multiple states have already passed legislation saying that if an Article 5 convention is called, the state legislature is in charge of that process. So then I'm thinking, wait a minute, in other times, Prohibition, it was called a convention to kind of get around Congress. Are we trying to get around Congress now? And then I think there would be no limit on it, that once the conventions were called, and then it would go straight to the states for ratification. And if it's 3/4 of the states must ratify, we could have a brand new Constitution. We could have amendments to this Constitution. So I think it's there for a reason, because people were concerned that if Congress always had the final say, you never get the amendments you wanted. But then there's another question about 2/3 of these conventions, or excuse me, 2/3 of the states can move for such a convention, and who knows what would come out of it.
Now, we're going to take one more question before we break, and these two issues are related, and so we've gotten a couple questions. The concept that every state has 2 senators, was a compromise that was created at a time where we had a much more rural country. The population wasn't quite so unevenly distributed.
Well, and there was a system of slavery that, as you know, was a factor as well.
Was good point. And so the question is, if there was going to be a change to how the senators were distributed, and in a companion, if there was going to be a change to the Electoral College, both of those would take constitutional amendments, or would they not take it?
Well, in terms of changing the equal representation of every state in the Senate, that is specifically banned by Article 5, the amendment process. There are 2 things that were banned in Article 5. No constitutional amendment could change equal representation of states in the Senate, and then also no constitutional amendment could abolish the slave trade before 1808. But when people look at the problems with the Electoral College, I just want people to remember basic algebra. Now that the issue with this Electoral College was that enslaved people were not represented. Now that slavery has been banned, people of all races are supposed to be represented. And then when you add 2 senators across the board, algebra tells you as long as you add 2 to everybody, that's not really changing the fundamental power relationship. So the issue with the Electoral College is not 2 seats for the senators, it's the fact of winner take all. That every state, instead of allocating electors proportionally to their own popular vote, does winner take all. And that's what creates such a skewed system. So, and that can be done without a constitutional amendment. There's, called this interstate compact. People would say, well, we're agreeing to throw our electoral votes to the winner of the national popular vote. I'm actually against that. And state compacts are there's a problem with those under the Constitution too, because Article 1 limits those. But nothing prevents any state from giving a more just allocation of electors according to its popular vote. That could be done tomorrow. And if states were willing to do that, I think that creates a better playing field for all parties, all interests across the board. And then you would have a result that was more in line with what the actual national popular vote had been. You could still have states tallying up the votes. That system is allowed. It's certainly allowed for members of Congress. And you could then have something more representative of the people. So there's a lot of things. Constitutional amendment doesn't have to be our only fix. We have to fix the problem. Congress could fix the problem. Congress has the power to regulate elections. It could say, we are going to require states to allocate the electoral votes this way in terms of percentages. I don't know what this Supreme Court would say, but the current system has to be approved by state legislatures. They're the ones that have the right to choose the electors. And whether or not they can make election results just as it is now with winner take all, perhaps ultimately that's going to be a question for the courts. But I think the people have to demand it. This is where we're seeing where our right to protest, our First Amendment rights, are really instrumental to civic change. And we can demand that electoral votes be represented according to the popular vote in each state. That's not too much to ask.
All right, gives us lots. We're gonna come
back
back
to the First Amendment.
We're gonna come back with a few more, questions in our extra time, but we want to be respectful. We have always set these in so that they close at 1, so people
absolutely
have joined us can feel that they have been full participants. And
please forgive the screen share. I'm afraid to cut it off at this point because I don't know if I'd lose you.
Okay. Now what we do at this point is we talk about the upcoming events, and we want you to know that our listeners to know that our upcoming events, we do have a special symposium that is coming up on Mary McLeod Bethune. And the very exciting information is that for the first time, we are going to have in the National Statuary Hall collection an African American from Florida. Mary McLeod Bethune is actually replacing a Confederate general. And from 2 to 4 on July 13th in the Capitol Visitor Center auditorium, we will have scholars from our participating partners, Bethune-Cookman University, the Roosevelt Library because of her closeness to Eleanor Roosevelt, and the National Council of Negro Women, which she started, talking about the life and legacy of Mary McLeod Bethune. The symposium is free. The QR code here, if you take a picture of it, you can go right there and register, which is a great opportunity. And on July 21st at noon, we are going to have a fuller discussion of the Second Amendment. And we have really a great set of speakers. Duke University has created a special study group on firearms law. And they have determined that they want to be fair and balanced and look at how does firearms law operate in this time, and how does that relate to the Second Amendment? So we're just honored to have those scholars. Linda, we're so grateful to have you here. We're grateful to our participants who are here with us. We always remind you that we are chartered by Congress, but we are funded by the people who listen and the people who make their contributions. And so thank you, thank you, thank you. Keep those cards and letters coming, keep your membership up, and share the invitation to participate with others. Look at the sort of silver lining of the pandemic, that we could create these webinars and offer our information across the nation. Occasionally, we've even had people from other countries join us. And so we thank you very much. Thank you for being with us. We now conclude the formal part, and now we're going to the after times. So Linda, you don't need a PowerPoint for this. This is just give it to us off the top of your head. Give us the lay of the land. Some people have been advocating a hate speech legislation. What do you think about that in the context of First Amendment and free speech?
Well, as you know, the Supreme Court has already struck that down. So an amendment, you said a constitutional amendment then. I honestly stand by the principles that Justice Jackson enunciated in terms of government can't choose. On the other hand, I think much more could be done for helping people who are harmed and protection against actual threats of violence. That's not hate speech, that's hate action. And we have too high a threshold for what are essentially imminent threats. And we saw the testimony of the January 6th committee, the women who were electoral workers who, many of them are volunteers trying to participate in the process. And that's not horrific. Those kind of death threats, those are not, that's not empty. Those are particularized. And the Supreme Court has also said that particularized threats, you know, it's one thing horrible to say in general, some group, that's bad enough. It's horrible enough. But when you particularize a threat to a specific human being, that is not any definition of free speech. You know, we don't need a constitutional law to punish that. We need political will. It's like we can find those people, we can trace them down, and we can convict them. And we should, much more so.
Now, talk to me about another kind of free speech. There's a case before the Supreme Court about a coach praying on the field who's arguing that that's free speech, freedom of religion. What are your opinions, and how do you look at that as a constitutional scholar?
Well, and I would add to that. I think one of the reasons, if I can give a little plug here, that my books are popular is because I deal with the facts. I don't try and speculate where the Supreme Court's going in my books. And I give, I focus on the actual rulings, and I give multiple viewpoints throughout in terms of controversial and current issues. So, you know, my point of view as an author is it's up to you to decide. Here's the information, you decide. That said, I've been at this a long time, 35 years. And I do have, I would say, considered opinions based on my work and my scholarship and my attention. And on the issue of the coach and the 50-yard line, until now, the Supreme Court has said that teachers, and recall that coach is a teacher at that point, a teacher at a public school. Private schools, it's not an issue. It's a public school because you're using the power of the state. And in the coaches that I know, they don't just get to stop at the 50-yard line and then the teacher duties are done. They have to go make sure if they're traveling, the kids get on the bus, et cetera, et cetera, et cetera. So in my constitutional opinion, for a coach to say, okay, it's the end of the game and I'm going to go to the 50-yard line now and say my prayer, he's still, as we would say, under the color of the law, he is still a teacher. And the reason the court has carved that out, you know, Congress can say prayers. The court has said that's okay. They're adults. We don't think that anybody's being coerced or that the state is endorsing religion. That's been the test up till now. But a school is different. A school, kids are required to be there. It's compulsory. If you want to be on a football team, you have to be there. And that's been the line that the court has drawn. And I personally, given the direction that they're going, I imagine they're going to say this individual right to free exercise of religion trumps the Establishment Clause, trumps the idea that government is not supposed to be in this role, particularly with children. I'm dismayed by that. I think the Establishment Clause is a big part of why we enjoy so much religious diversity. And we're one of the most religious nations in certainly the Western world, but it's because we keep government out of it. And it seems like that idea is, at least 6 members of the Supreme Court don't really believe in that anymore.
So we're going to do our last question, and I want to alert people that as we send the video, we will include information about how to get a hold of Linda's books and Linda herself. If you'd like to follow up with her, there's several people who seem to be so interested in your talk. You may end up with another invitation out of all.
Well, I appreciate that. And I want to give a shout out in these times, particularly, you know, our nation's teachers are frontline responders at this time. They've always been to our children and our students, but this time more than ever. And, you know, I just want to give a huge shout out to the work they do every day to make sure that we wake up in a constitutional republic. They're doing that heavy lifting for all of us. And I am proud that I have so many teachers as colleagues and personal friends.
That's great. Okay, one line answer and then a little more sophisticated answer. Is there
Somebody wants to bottom line me? Wait a minute.
is there a TV journalist you actually trust to understand the Constitution and present it to us?
And I would say you should never listen to one person, ever.
Okay, so the answer.
I'm sorry. Did I?
This is no. You have to say yes or no, and if there is it, who would it be? You can say no. You can say there's nobody in particular.
No, what I can say now, this is my First Amendment. What I can say is watch a variety.
Okay.
Watch a variety on the issues of the day. Watch the variety of the issues of the day, because I have yet to meet a scholar that doesn't get it wrong. And even if you disagree, you need to understand what the rationale is on the other side.
And so here's the final question, because you talked about social media a bit, and you talked about teachers a lot. There's been conversation about what's the right of schools to look at students' social media and to have consequences for that. How does that relate to freedom of speech?
Well, I'm so glad I was prepared for some of this. The Supreme Court's issued that ruling in the Mahanoy case and said, wait a minute, students have rights outside of the school, constantly checking them on social media. And I agree with that too. Schools are being asked to do so much. Teachers are being asked to do so much. And we can't expect teachers in schools to always be doing the jobs that parents used to do. Parents have to step up too, in terms of if you think your child is being inappropriate, if you think your child is certainly a threat or a danger to anyone. Social media is part of our landscape. The school couldn't publish a student who wrote a letter to the editor about the school, could they? No. You can't always control what students are going to do, or else there is no First Amendment for students as well.
Well, Linda, we could listen to you for another hour, but we're going to give you a break. And we thank you so very much. And we thank you to our listeners and the dedicated folks who stayed with us. We look forward to seeing you at the Bethune Symposium, which is going to be both in person and virtual. So if you're in the Washington, D.C. area, you can come to see it at the Capitol Visitor Center. And if not, you can tune in and join us from wherever you are. But then in July, looking at the Second Amendment. Thank you very much. And we invite you, as always, if you have thoughts about things we should pursue, let us know. We are always trying to respond to the needs of our listeners and our engaged folks. Thank you very much, Linda. Thank you, Sam, Yanni. It's an incredible staff here that pulls this together. I just get to be the one talking, but the work that goes on behind the scenes is other people. Thank you so much. Be well. Have a good day.